Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with transferring earnest money from one terminated transaction to a new transaction. So, stay tuned. I will explain to you at the end what you need to do, what you need to actually have signed by your buyer. But let me back up and explain the situation. So let's say you're working with a buyer and the buyer goes under contract for property number one. They put in earnest money, your broker's holding earnest money, and they go under contract. Brokers made the deposit, the funds are good, and the buyer terminates that transaction under due diligence for whatever reason. Buyer then goes and finds another property. The buyer wants to use that earnest money that's on hold with your broker or the holder, whomever the holder is, for property number two. How do you go about doing that? Can you do that? Well, the answer is yes, you may do that given a few circumstances, but you must get written permission from the buyer. So let's back up. Let me back up even more and let's go through everything and make sure that you have a sense of what we're talking about. So buyer's under contract. Buyers, like I said, turn in the earnest money. It's been on deposit, no issues. They terminate under due diligence. Buyer immediately finds property number two. Well, seller number two is going to want what? Yes, earnest money. So the question is, may you use the earnest money on deposit from terminated contract number one as earnest money for contract for property number two? Here are the things you need to go through in order to do this. And this is a discussion you need to have with your buyer as well as, well, let me just go through everything. So first thing to check out is the termination of contract number one. Was there a fully executed termination and release? Termination was done. What we really need is, did the seller sign off agreeing that the buyer is entitled to the earnest money back? So if you have both buyer and seller signatures on the release portion of a termination and release, then yes, the buyer may use that earnest money already on deposit with the holder for a second contract. There's still something that has to be done, so I'll get to that in a minute. Stay tuned. However, if the buyer terminates contract number one, sends a TNR, but the seller, for whatever reason, won't sign the release of the earnest money, buyer finds property number two, buyer may not immediately use the earnest money on deposit with the holder for contract number two. Buyer is going to have to put in additional funds for earnest money. Why is this? Well, it's not the buyer's earnest money yet. If the seller does not sign the release portion of a TNR, then the holder must, if it's a broker, the holder can either do the 10-day letter and go through and interpret the contract and find out, why did it fail to close? Did the buyer terminate based on an unexpired contingency? In other words, did they terminate, for example, before due diligence had expired and the seller just won't sign it for whatever reason? Did the buyer default on the contract? For whatever reason, those funds are tied up until that earnest money on terminated contract number one gets resolved. Either it's resolved with a 10-day letter, and if that's the case, those funds are not available for the buyer to use on any other contract for at least the 11 days, 10 days after that notice is written, as long as there are no issues. Or it could go to court. It could be interpleaded, an interpleader action with the court. If the closing attorney is holding the earnest money and the parties are binding on a GAR contract and it was a cash transaction and the seller doesn't sign the release portion of the TNR, it has to go to court. So y'all pay attention to that. I've done several videos on that. The other issue is, let's say the earnest money, let's say the buyer put in a personal check for the earnest money, and the holder has a policy that they're not going to act on that earnest money for 10 banking days, and the buyer terminates contract number 1 on, let's say, day 3 from binding agreement date, seller signs off on the TNR, the buyer still may not have availability of those funds to use on contract number 2 because the broker, they haven't gone through the broker's policy of good funds policy. And license law says there has to be good funds policy. So I'll get to some points of practice in a minute. But let's go back to best case scenario. Let's say buyer goes under contract with property number 1, sends in earnest money, it gets deposited, it was a certified check, so there's no hold on it, everything's fine. Terminates contract number 1, sends a TNR, the seller signs off on the R part of the termination and release. The holder still may just reallocate that earnest money deposit to property number 2. However, the holder may not simply do that based on what you as a real estate agent tell the holder to do. It's not your money. It's not your earnest money. You as an agent, you need to get the buyer's written permission to the holder to transfer that earnest money that's allocated for property number 1 that was now terminated to property number 2. It's not your say-so what the holder does with that money because it's not your money. The broker may not automatically allocate those funds for another property. It's not the broker's money. So you absolutely need written permission from the buyer in order to transfer that earnest money being slated for one property to another property. Check with your broker, check with the holder, come up with something at Maximum One Companies. We do have a form called Transfer of Earnest Money from one property to another property that does identify the property that was terminated, the amount of the earnest money, the property that the earnest money is now to be allocated towards, with a place for the buyer to sign, giving us written permission to not return those funds actually back to the buyer per the contract, per the TNR of contract number 1, but to keep them on hold, on deposit, and just allocate those funds as earnest money for a second contract. So, points of practice for you real estate agents. What does all of this mean? This means, number 1, it's best to deal with certified funds for earnest money rather than a personal check, because that way you avoid any brokerage policies on holding personal checks to make sure everything has cleared the bank. Number 2, if you are dealing in all cash, I strongly suggest you have one of the brokers hold the earnest money rather than a closing attorney, because read those documents if you're binding under the GAR contract, GAR F510 and F511, that talk about the earnest money, that talk about the closing attorney as the holder of the earnest money in all cash transaction. If there's a dispute and you don't get the seller signing the agreement to release, it must go to court as an interpleader action. Number 3, if you are going to, if there is a chance that the seller is not going to sign the release of the earnest money upon termination for buyer number 1, you need to let the buyers know that they're going to have to write more money. They're going to have to pull more money out of their account as earnest money for contract number 2, because the earnest money for contract number 1 is tied up. Now, they will potentially get it back. It depends on the circumstances surrounding the termination, so forth and so on. They will get it back, but seller number 2 is going to want the earnest money immediately and not have to wait 10 days, 11 days, 12 days, for whatever, however long of the time. Now, sometimes the seller won't sign a TNR because the seller is upset. Sometimes the seller won't sign a TNR because the listing agent can't find the seller. Sometimes the seller won't sign a TNR because let's say it was an issue where buyer and seller were under contract, seller passed away, the estate is not through probate, there's no one on the seller side that can sign. So in that situation, it would have to go through the 10-day letter process. Buyer, if they find another property, seller number 2 is going to want earnest money. So these are all sorts of issues that you as the real estate agent need to discuss with your buyer, deal with certified funds, and if everything is best case scenario, you need to make sure that you get your buyer's written permission for the holder instead of actually returning the funds back to them, as the contract states the holder is going to do. Actually keep those funds on deposit, reallocating them as earnest money for contract number 2. And so what do you do in contract number 2? If it's best case scenario, buyer gives permission to reallocate the funds from terminated contract number 1 to contract number 2. How do you fill out contract number 2? Well, in the section where it talks about earnest money, instead of putting buyer to remit earnest money X number of days from binding agreement date, they're already on deposit. So you are going to mark the box that says the holder is already in possession of the funds. Or it says, I believe, buyer has remitted funds to holder. So that's how you'd fill out the contract. Hope this contract tip helped you out. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.